Public international law consists of the legal norms, treaties, and conventions that regulate the interaction between sovereign states, international organizations, and individuals. It provides a structured framework for governing international relations and addresses various global concerns, including human rights, environmental protection, trade, conflict resolution, and the laws of war. The purpose of public international law is to ensure peaceful coexistence among nations and to facilitate cooperation to uphold security and justice at a global level. India's legal perspective on public international law is shaped by its commitment to sovereignty, peace, and justice while ensuring compliance with international treaties and obligations. As a sovereign state, India operates within the framework of public international law like other nations. However, its approach remains unique due to its historical background, constitutional provisions, and foreign policy principles. Since gaining independence in 1947, India has played a proactive role in shaping international law and advocating for the rights of developing nations. It has consistently emphasized equity in international trade, fair representation in global institutions, and the establishment of a just global order. India's participation in global legal frameworks has allowed it to contribute to the evolution of international norms, particularly in areas that impact developing countries. The Indian Constitution establishes the foundation for the country's engagement with public international law. Article 51 Clause C of the Constitution highlights the importance of fostering respect for international law and treaty obligations, demonstrating India's recognition of global legal frameworks as a guiding principle in foreign policy. However, India also prioritizes national sovereignty, ensures that international commitments do not undermine domestic legal autonomy. This balances between the international cooperation and national interest is a key characteristic of India's engagement with international law. Article 51, Clause C of the Indian Constitution establishes a guiding principle urging the state to promote respect for international law and treaty obligations. However, this does not suggest that international law is disregarded within the Indian legal system. In Anna Kumaru Pillai versus Muthupayil 1907 case, the Supreme Court upheld the concept of historic title based on prescription and acquiescence, thereby recognizing and enforcing an international customary norm. On the other hand, in ADM Jabalpur versus Shivakant Shukla 1976 case, the Supreme Court dismissed the argument that the Universal Declaration of Human Rights was part of municipal law, categorizing it as a set of ethical guidelines and interpretation that faced significant criticism. Justice Khanna, in his well-known dissent in the ADM Jabalpur case, maintained that when municipal and international laws are in conflict, municipal law takes precedence. However, if a municipal law allows for two possible interpretations, courts should favor the one that aligns with the international law and treaty commitments. This perspective was further affirmed in Vellore Citizens Welfare Forum versus Union of India 1996 case, where the Supreme Court ruled that the precautionary principle and the polluter pays principle had attained the status of international customs, making them a part of Indian law. Therefore, the Supreme Court recognizes international customs as an integral part of Indian law as long as they don't directly conflict with existing domestic legal provisions. India's approach to treaty implementation aligns with elements of both the English and American legal systems. When an international treaty influences existing laws, imposes financial liabilities, or requires legislative approval for execution, legislative intervention becomes necessary. Additionally, the Supreme Court of India in Magan Bhai Ishwar Bhai Patel versus Union of India 1970 case acknowledged that the distinction between self-executing and non-self-executing treaties, reinforcing the nuanced application of international agreements within the domestic legal framework. India's commitment to international treaties and conventions is evident through its membership in various multilateral organizations and agreements, including the United Nations, the World Trade Organization, the International Labour Organization, and the International Court of Justice. India actively contributes to the development of international norms through these platforms, which engages in policy making, peacekeeping, and diplomatic negotiations. Its involvement in UN peacekeeping missions showcases its dedication to international peace and security, reflecting its broader vision of maintaining stability in conflict-prone regions. Despite its active participation, India follows a dualist approach to international law, meaning that treaties and agreements do not automatically become part of domestic law unless they are incorporated through legislative action. International treaties require parliamentary ratification before they can be implemented within the country's legal system. This principle ensures that any international commitment aligns with India's constitutional framework and national interests. Several legislative enactments reflect India's adherence to international legal obligations such as domestic laws related to human rights, environmental conservation, and trade regulations. India's foreign policy aligns with its legal approach to public international law. It strongly advocates for principles such as self-determination, non-intervention, and respect for state sovereignty. These principles are particularly evident in India's stance on territorial disputes, including its position on Kashmir, where it insists on a peaceful resolution in accordance with the international law. India has also championed the right to development for the Global South, which emphasizes the need for fair distribution of globalization's benefit among both developed and developing nations. The Indian judiciary has played a crucial role in integrating international law into domestic legal interpretations. Courts have frequently relied on international conventions and treaties to shape legal decisions and to uphold constitutional rights. A significant example is the Vishakha versus State of Rajasthan case, where the Supreme Court incorporated international human rights principles to address workplace harassment, relying on the Convention of Elimination of All Forms of Discrimination against Women, in the absence of specific domestic legislation. This approach demonstrates the judiciary's willingness to interpret domestic law in harmony with international obligations when necessary. Another instance of India's interaction with international law is its involvement in international arbitration and dispute resolution. India has participated in several cases before international tribunals, including arbitration proceedings related to investment disputes and territorial conflicts. The country's engagement with international arbitration mechanisms highlights its commitment to upholding international legal standards in resolving cross-border disputes. Despite its adherence to public international law, India has expressed reservations regarding certain international instruments that it perceives as threats to sovereignty or national interest. For instance, India has not ratified the 1951 Refugee Convention, citing concerns over resource constraints and national security implications. Similarly, India exercises caution in its dealing with international human rights mechanism, arguing that some global frameworks may be used to exert political pressure on developing nations. These reservations reflect India's strategic approach to international law, ensuring that its commitments align with its domestic priorities. As a rising global power, India is increasingly involved in shaping international legal norms to reflect contemporary geopolitical realities. Its calls for reform in institutions like the United Nations Security Council, which highlights its commitment to creating a more inclusive and representative global governance structure. India's economic and political influence positions it is a key player in international decision making, which allows it to advocate for changes that address the interests of emerging economies and developing nations. India has been particularly vocal in the area of global environmental governance, advocating for climatic justice and equitable responsibility in addressing climate change. It has consistently argued that developed nations should bear a greater burden in mitigating environmental degradation due to their historical contributions to carbon emissions. India's stance in international climate negotiations, including its participation in the Paris Agreement, which reflects its commitment to ensure fairness in global environmental policies. In international trade law, India plays an essential role in shaping policies within the World Trade Organization, advocating for fair trade practices that benefits developing countries. It has raised concerns about the impact of trade liberalization on small-scale industries and farmers in the global south, calling for reforms in global trade which rules to prevent economic disparities between developed and developing nations. India's proactive participation in trade negotiations demonstrates its effort to balance economic growth with equitable international trade regulations. India's engagement with public international law reflects a pragmatic approach that carefully balances international obligations with national interests. While the country actively participates in shaping global legal frameworks, it remains cautious about commitments that could undermine its sovereignty. By advocating for a fair and inclusive international legal order, India continues to play a significant role in global governance. Its growing influence in areas such as environmental law, trade negotiations, and peacekeeping highlights its evolving position in the international legal landscape. Through its involvement in public international law, India not only seeks to safeguard its national interests but also contributes to global peace, security, and development. By fostering respect for international legal principles, participating in multilateral organizations, and promoting equitable global policies, India demonstrates its commitment to building a just and stable international order. As the world continues to face new challenges in areas such as climate change, trade, and geopolitical conflicts, India's role in shaping international law will remain crucial in ensuring a balanced and a fair legal framework for all nations.